My name is Alexis, and I'm the marketing and community manager at North Coast Ventures. North Coast is a Cleveland based investment fund investing primarily in early stage B2B software as a service ventures. We have more than 300 member investors and have deployed over 65 million into 60 startups in the region. In addition, we have a group of corporate partners like Dinsmore that make up what we call our Innovation Council. These are partners that we work with on a local, regional, and multinational scale. These partners are dedicated to helping promote startup growth and sharing their industry expertise. To provide a medium to do this, North Coast launched a lunch and learn style webinar series where members of our Innovation Council share their knowledge on a relevant and timely topic. Today, 4 members of the Dinsmore team, one of which is actually a North Coast Ventures investor, will talk through how to protect company assets through IP mechanisms and cybersecurity. Today's session will be recorded and a link to the recording will be shared later today. We will also be taking questions at the end of each session. Please feel free to type your questions into the chat and we will address them at the end of each section. I am now going to turn it over to Jim from the Dinsmore team, who will kick off the presentation.
Thank you very much, Alexis. I want to thank all of you for joining us today, and I also want to thank North Coast Ventures for providing the opportunity for us to speak with all of you today. As Alexis mentioned, we will be presenting on protecting IP assets through IP mechanisms and on cybersecurity. We'll provide an overview of these topics to help each of you identify issues in these areas. Next slide. I'm Jim Dimitrievs. This is a picture of me wearing a suit from a different time in a different era when a lot of people used to wear suits. I'm the managing partner of the Cleveland office of Dinsmore and Scholl. In my practice, I focus on protecting brands and companies, including major retailers worldwide. Next slide. Before introducing our speakers, I'd like to take a few minutes to tell you a little about our firm and its history. This is a picture of an even more distant era of a bunch of guys in suits. Next slide. Dinsmore started in 1908 in Cincinnati. The founding partners gained notoriety for defending a banker by the name of George Cox in actions for violating banking laws. The firm gained acquittals in both actions. Since then, of course, the firm has had success for many clients in many different actions. Some of the firm's larger clients include Procter & Gamble, for which the firm has handled labor matters since the middle of the 20th century, Toyota, and one of the world's largest retailers. However, our lawyers leverage the experience that we gained from representing larger companies to assist mid-market and startup companies with both IP and cybersecurity issues, as well as other matters. Next slide, please. During the 20-year period of 1987 through 2007, Dinsmore and Scholl expanded regionally from Cincinnati to Dayton and Columbus in Ohio, but also to the surrounding states of Pennsylvania, West Virginia, and Kentucky. Next slide, please. In the following 15 years, Dinsmore expanded to more cities in those neighboring states and also added a DC office. Next slide, please. In 2014 and 2015, Dinsmore transitioned to a more national footprint by adding offices in California, Colorado, Illinois, Michigan, and Connecticut. Next slide, please. The national footprint has continued to grow in recent years with not only more offices in the states where Dinsmore had already expanded, but also new offices in Indiana, Georgia, Florida, and Massachusetts. Next slide, please. Now we are a firm of over 725 lawyers and 29 offices, and we have gained recognition from several notable publications and organizations, not only for our growth and size, but also for our diversity and the accomplishments of our lawyers. Next slide, please. Our most significant practices include IP, corporate and transactional, labor and employment, litigation, and finance. Next slide, please. Myself and 2 other lawyers joined Dinsmore to start the Cleveland office in 2017. Next slide, please. Since then, the practice areas in the firm in the Cleveland office have grown to include banking and financial services, cybersecurity and data privacy, environmental law, IP, litigation, public finance, workers' compensation, and more. Today we have 3 speakers from our Cleveland office, and they are Stephanie Williams. Oh, I'm sorry, next slide, please. Oh, I'm sorry. Grant Monachino, who focuses his practice on selecting, protecting, and enforcing brands for products and services in the US and throughout the world. Next slide, please. Stephanie Williams, a patent attorney experienced in advising clients on patent infringements, validity, freedom to market, and patentability issues. Next slide, please. And Richard Sarkar, who advises clients on issues of cybersecurity, as well as commercial and consumer disputes. He also litigates these issues for clients when necessary. With that, I'll turn it over to Grant.
Thank you, Jim. And thank you to North Coast Ventures for giving us the opportunity to talk with you today. Next slide. So what I'm going to talk about today are trademarks as ways to protect company assets. Back one slide, if you will. This is a very brief introduction to trademarks, and I'm only going to touch on essentially one aspect of the trademark portfolio process. But the one takeaway I'm going to try to establish today is that focusing on branding a company's products and services with strong trademarks that are considered to be, quote, available for use is, one, a relatively inexpensive way to differentiate your company and its products and services in the marketplace. 2, it's a way to increase company value through related consumer goodwill. And 3, it's a way to potentially make your company more attractive or valuable to investors. Next slide. So here's what I'll try to touch on in the next 12 to 15 minutes here. A brief introduction to a brief trademark foundation, I should say, along with some main reasons why you should care about trademarks, the trademark selection process, trademark selection and clearance process, I should say, as one of the most critical, if not the most critical step in the life of a trademark, and some common errors or pitfalls that can take place in the selection and clearance of a trademark, and some practical ways that you can issue spot to try and avoid these pitfalls. Next slide. So what is a trademark? In general, it's a source identifier for either goods or services. Said a different way and more along the lines of how it's defined is, in its broadest sense, any word, name, symbol, slogan, device, design, can be a color, a touch, a sound, smell, or some combination of any of these items that identifies the source of the goods and or the services used in connection with the mark and distinguishes that source from others in the marketplace. Trademarks that consist of words, which is what I'll focus on mostly today, are the most common, as they have the flexibility of being not only seen, but heard. And one item to just clarify here is some folks will differentiate between trademarks and service marks based on the offering that is used in connection with the source identifier. I use the term trademark synonymously to include any source identifier that is associated with either a good or a service. As you may notice in the slide that's up there, there are maybe some recognizable brands for the folks on the call, and maybe some recognized, well-known designs that are up there. Next slide. So what are the main functions of a trademark? First, they indicate the source or origin of goods or services. Second, they assure consumers of the quality and consistency of goods or services that are used with the mark. And the third main function is to create business goodwill and brand awareness. Next slide. So why do you care, or should you care about trademarks? Trademarks are the most common form of IP encountered by people in their lives every day. Branding, as I'm sure you know, is everywhere. Everyone deals with trademarks or brands on a daily basis, whether that's retail or business consumers, when they're making purchasing decisions, and there's this constant influence of trademarks in that process. Trademarks can act as landmarks or quality indicators and differentiators, which in many ways is they provide brand awareness, help you to distinguish your products and services from competitors. Trademarks limit consumer confusion. For example, if you went to buy a can of soda, such as a Pepsi, and you saw a can labeled as such, but it didn't taste like a Pepsi, you'd probably be confused or disappointed or angry at whoever had provided you that product. Trademarks are a way to ensure reliability, convenience, so there doesn't have to be any checking as to whether or not the product that's associated with that is what you expect, and consistency, especially with quality. Next slide. Trademarks are efficient communication tools. Trademarks can say a lot in one word or symbol about a company, reputation, the products and services that are used with it, with the brand, or also provide consumers with lifestyle or aspirations and relate to areas of their life that are desirable. Trademarks can reduce the cost of decision-making by consumers because they allow consumers to select a product or service from competitive offerings with relative ease. Trademarks can be long-term and enduring assets. Essentially, trademarks can continue indefinitely as long as the trademark is neither abandoned by its owner or it does not lose its trademark significance. Trademark rights can increase in value over time, can be one of a company's most valued assets. They can be leveraged for, let's say, brand expansion. They can be leveraged in the context of sale or licensing or used as collateral or security. In the slide that's up there, the Samson trademark that is shown at the bottom is one of the longest standing trademarks in the United States. It's over 130 years old. It's used for, this is probably not as familiar to some folks, but it's used for cords, lines, and rope, which over 130 years ago was probably pretty innovative at the time. And then there are some other brands I identified there that may be more or less familiar, especially the last two on the right, in the venture capital and the software as a source space. Next slide. Trademarks can support higher margins and more consistent pricing, especially when there really aren't differences in products. The brands may be what drive margins. Trademarks are relatively cheap to obtain and maintain. I consider trademarks to be, in many ways, cheap insurance. A trademark can be indefinite and become more valuable to the business over time. And this again makes the cost of acquiring and maintaining such rights relatively cheap. Trademarks are flexible. As mentioned in the definition, practically anything perceivable by the human senses can operate as a trademark. Trademarks are effective enforcement tools against unfair competition. Trademarks are often easier and cheaper to enforce than other forms of IP. And when you protect your trademarks, you are protecting your reputation and retaining your customers. Next slide. Finally, and maybe most relevant to this audience, there's been research to suggest that the number of trademarks held by an entrepreneurial firm is associated with greater venture capital investment spread over a smaller number of financing rounds. It's also been associated with a greater probability of successful exit, greater probability of higher IPO and secondary market valuations, greater institutional investor IPO participation, and better post-IPO operating performance. And so trademarks have been associated with those advantages based on indicating and signaling to the market a company's marketing capabilities. Having a trademark portfolio enables a firm to better perform in the marketplace and differentiate its products. It also can be tied to innovation. Typically, innovative products and services are branded in ways to differentiate them as well. Next slide. So I've touched on why trademarks matter, and here is sort of how, generally speaking, a company would build a trademark portfolio. In the next couple of slides, though, as I mentioned earlier, I'm just going to focus on the selection clearance quadrant, but as you can see, there are other aspects of building and maintaining a trademark portfolio. Next slide. So ideally, a business would follow a three-step process for adopting and protecting a new mark. There is the selection aspect, the searching and clearance aspect, and then the establishing rights / protection aspect. Next slide. Selecting the right trademark is, in my opinion, one of the most crucial decisions a company can make. So the first step is to identify possible names or logos, potentially with the assistance of marketing or other related consultants, about how you want to, what names or logos you want to use for a new product or service. Trademarks, as they're being selected, will land on this distinctiveness spectrum that is identified on the slide here. The distinctiveness spectrum is considered in the context of the goods or services with which the proposed mark is going to be used. Hence, Apple for computers is considered to be arbitrary, as opposed to apples for sort of an orchard would be on the generic end of the spectrum. Some rules of thumb in trademark selection to consider are: the more distinctive a mark, the greater its level of protectability. Any of the marks you select that are on the arbitrary or fanciful side of the spectrum are considered to be more inherently distinctive and therefore easier to protect and inherently stronger proposed brands. On the flip side of that, on the other end of the spectrum, generic terms or symbols are not considered to be capable of trademark protection. And in the middle, descriptive and suggestive, sort of a fine line between those two areas in which a proposed trademark might fall. Descriptive terms are on their face not protectable, at least initially, but descriptive terms or symbols are capable of protection if they can be considered or deemed to have acquired distinctiveness, which is usually through extensive and exclusive use, as well as consumer recognition. So when you're thinking about the proposed brand you want to use for a product or service offering or a company name, these are things to consider, in particular, this distinctiveness spectrum. Next slide. The next step is to rule out marks that are not registrable or protectable, which, it's said another way, is proposed marks that might be considered high risk when it comes to using them or adopting them. This step should include conducting one or more searches to make sure the mark is available, or quote, available for use, which is to say lower risk for the business. And it's possible that the relevant trademark office, for instance, the US Patent and Trademark Office, is likely to award the owner a trademark registration. So the searches here are to determine if a prior conflicting right exists, or to reduce the likelihood that your use of the brand will be considered infringing. And the other benefit of a search is to gauge the distinctiveness of a mark commercially as opposed to inherently. The one way that this can be done as a way to essentially rule out the possibility of pursuing certain proposed marks is a screening search, which is essentially doing a search of the internet and at the US or in the US, the US Patent and Trademark Office database. It's a pretty cheap way to figure out, are there red flags that are out there? To take a look and see if what you're proposing as a mark is something that is already in the space or a similar space to where you're going to operate or your business operates. A screening search is not to make you feel comfortable about the fact that a mark is, quote, available. It is, in my opinion, its usefulness is to identify red flags. And so that is the first step. If there aren't red flags identified, the next step is a full search, which is typically done with a vendor that is more costly and is more robust. And to interpret the results, that usually involves getting a trademark expert involved in-house or outside counsel. Next step, or next slide. So the two common errors that take place in the selection and clearance process, one is selecting weak marks for adoption and use, and the other one to try to avoid is failing to clear the marks that you're going to adopt and use. We talked a little bit about the distinctiveness spectrum. This is where you want to avoid inherently weak marks that fall on the generic or descriptive side. And the avoid commercially weak marks is where you've done a search and you found that even though the term, let's say, is not considered to be descriptive or generic, there are a number of folks that are already out there that are in that space and it's a crowded field. It might lead to coexistence, but the strength of what you can do with that mark is going to be limited based on the crowded nature of the field. The other pitfall to avoid is failing to clear marks. You don't want to spend a lot of time, money, effort, and resources on a brand just to find out that there's somebody else that's out there, maybe at the most inopportune time, that already has earlier rights and now is sending you a demand letter looking to have you stop what you're doing. Next slide. Here, very quickly, I want to just identify two ways that you can, as a business, do this sort of screening process. One is through an online internet search. I've identified here as an example the advanced Google search, which I find is pretty useful because not only can you search for certain items, you can do an or search to sort of narrow the limit of the industry or field in which you're searching. So in this case, I just picked the term pinnacle. I identified thinking about the venture capital space or the investment space, use words like investment or fund or management or capital. And the results that I came up with, there's a few of the logos that I pulled from the search results. There were already a number of folks that were in this space. If I had seen this search, this would give me some indication that if I was looking to be in a crowded field, I guess this is the place to be. If I was looking to avoid that, which I would advise if you want a stronger mark, this is probably not a brand to go with. Next slide. Similarly, I looked at Sequoia in the context of the same industry. There were less out there, but nevertheless, Sequoia Capital, which I is well known in the venture capital space, would be, in my mind, a red flag for purposes of adopting that mark. There's a couple of others that are out there as well, maybe worth some further review, but to try to quickly move on to your next selection, these are ways you can rule out proposed marks. Next slide. And lastly, there's the US Patent and Trademark Office has a database. This is to see who has filed for trademarks. You can, again, search the mark in connection with services or goods, get some sense of what's out there, dig into these with a little bit of practice, with a little bit of tutorials, some videos that are available on the website. you can go and do that yourself and figure out if somebody else already gone and filed for what you were thinking you wanted to use as your proposed trademark. And finally, skip to the last slide. There you go. So as I mentioned, I'm just touching on selection and clearance here. There's other aspects of as I've identified. We'll have to wait for another lunch and learn, because now I'm going to turn it over to Stephanie to discuss another important of IP and another IP mechanism, patents.
All right, thanks, Grant. Good afternoon, everyone. We're really excited to be here, so thank you for joining us. As Jim and Grant said, I'm going to be talking about patent mechanisms that investors and companies should consider. As far as my slides go, I'm going to give a quick patent primer, then talk about what it really means to have a patent, and then if you don't have a patent, should you get one? So there are three types of patents: utility, design, and plant. Utility patents are what people generally think of when patents come to mind. They are the most common. And these type of patents protect how something functions or works. Things that are covered by utility patents are devices, methods, things along that vein. The next type of patent is a design patent, and it protects the ornamentality or what a product looks like. And it's important to note that a product could be covered by both a design and a utility patent, as long as the ornamentality or what gives it its cool shape doesn't serve a functional purpose. And so if it's a shape that allows it to work the way it does, then you would not be able to cover that aspect by a design patent. So design patents, non-functional purposes; utility patents, functional purposes. And then the last type of patent, the least common, are plant patents, which protect new plant species that were altered by man. The rest of my slides will mainly focus on utility patents. I'll discuss design patents a little bit, but plant patents will kind of leave out of the discussion for today. All right, so what can I patent? A process or method, a machine, a manufactured article, a new composition, any improvements to those four, and then, as I said, with design patents, you can cover ornamental features of a product. What cannot be patented are things that occur naturally, so you can't go outside and cut that branch off a tree and try to patent it. However, if you carve that tree branch down into a baseball bat or something like that, then perhaps you can get a patent on it. Things that can be performed mentally, we don't want to limit what people can do with their brains. Business forms and scientific principles, particularly that are not tied to some kind of hardware. These are, for those who are familiar with the patent space, kind of fall under the abstract ideas, which has been a very hot topic for a number of years now. You know, not if something's not tied to a computer, you know, is that patentable subject matter? Perpetual motion machines, it's scientifically accepted that perpetual motion machines cannot exist, and so therefore you can't get a patent on them. And then some abstract algorithms that merely crunch numbers without any useful result also cannot be patented. Again, patents need to be patentable subject matter. It has to have some sort of usefulness at the end of it. All right, so if you're an investor and you're looking at a company that has a patent, or perhaps there's a competitor that has a patent, what does that really mean? When this comes to mind, I always think of Lori Greiner from the TV show Shark Tank, the queen of QVC. She's always asking people if they have a patent. What does that really mean? So a patent is a property right granted by the United States Patent and Trademark Office to exclude others. It is not a right to use. And so let me give you an example. So utility patents, which are used to protect the function of a product, their scope is determined by written claims included at the end of a patent. And so what I've included up here as an example is a Blue Willow Biologics application, Blue Willow Biologics being a North Coast Ventures active company, and they're focused on developing and commercializing anti-infective products and nasal vaccines. And so what is shown on the slide here is a currently pending claim 1 from an application that they just recently filed that is directed to the prevention and treatment of coronavirus and other respiratory infections using nano-emulsion compositions. And so the first bullet point of the claim is called the preamble, and then the second through the fourth bullet points are parts of the nano-emulsion. And so let's just say, for purposes of this example, that one of a competitor out there, company X, has a nasal spray out there that has A and B, has an aqueous phase and has a soil phase. And Blue Willow Biologics comes along and says, you know what, A and B just aren't working. It's just not providing the results that it should. And we think if we add a surfactant C, we're going to get all of these advantages. And so they file an application on A, B, and C. And let's just say it gets allowed as the claim is shown, and they are granted a patent. And so they have a patent on a nano-emulsion that includes A plus B plus C, and they themselves can exclude anybody else from doing that. However, Blue Willow Biologics cannot itself practice this invention, cannot use, sell, import this invention. It would have to go back to company X to license the rights to make a nano spray with A and B, because company X already has a patent on A plus B. So it's just important when you're thinking about what you have, what competitors have, really looking at the claims to know kind of either what you're excluding others from doing and what others are excluding you from doing. So utility patents would, you would find this information in the claims. For design patents, you would look to the drawings. Other things to consider when you have a patent, it is a quid pro quo situation. The purpose of inventions, of granting patents, is to advance innovation. And so by disclosing your invention, your product, and the details behind it, the United States Patent and Trademark Office is going to give you a limited time monopoly for that disclosure. There are some strategies that go into, how much information to put in a patent application and things like that. I do have some clients who are hesitant to, kind of give everything away. But for the most part, that's why the USPTO is giving you a patent, because you are disclosing that invention to help, to progress future innovation. And then also patents are territorial. There's no such thing as a worldwide patent. There are some international applications that you could file that kind of gives you the opportunity to take a first bite at the apple and see how your application will be treated in individual countries. However, you have to file in each country in which you want protection in. All right, so perhaps you're part of a company that has a product that thinking about pursuing a patent application in, and the question is, should you? Of course, there are many benefits of a patent. Gaining entry into a market. Again, Lori Greiner from Shark Tank always, it gives you that kind of credibility if you go through the patent application process and you're granted a patent. It gives you, investors and other people in the market kind of, look upon that as an advantage. Blocking close competition, as we just talked about, patents are a right to exclude. And so if you want to prevent competitors from kind of coming into your area, patents provide you with that opportunity. Receiving royalty payments by licensing out. Company X could have received some royalty payments by allowing Blue Willow Biologics to license out the use of A plus B. Use as a marketing tool, being able to put patent pending or patented on a product, again, gives you some more credibility in the market. And then it can be a metric for innovation within a company. How far are we taking this technology? It could be measured by the patent process. Other things to consider along with those advantages are time and cost first. Going after a patent could be cost prohibitive. It is and can be an expensive process. And then also it's a lengthy process. The pendencies up here for utility patents at the U.S. Patent and Trademark Office, from when you file to when you first even hear back from the USPTO is just over 16 months. And then the traditional total pendency, so that means you receive a notice of allowance, or perhaps hopefully receive a notice of allowance, perhaps it's abandoned. You're looking at almost 2 years. And in some, technology fields, that's just, not going to be, technology moves too quickly. And so perhaps it's just not worth going through the cost when by the time you get the patent on the wall, the technology is already way past your point. Also, and it's also important to think about that there is a difference between innovation and invention. And just because, a researcher spends years and years on something doesn't mean that their final results aren't valuable and aren't important. It may just mean that they're not patentable by certain legal criteria. To be patentable, you have to be useful, new, and non-obvious. And there are just some products out there that may not meet those 3 criteria. And so, these are just all things, so kind of to answer the question, do you need a patent? And the attorney answer, it depends. These are all business decisions that need to be made, and it's a very strategic process that you need to go through. If you decide that, pursuing a patent application just isn't right for you because of time, cost, maybe there's other competitors out there that are just going to prevent you from obtaining a patent, but you still want to make sure you're not infringing other people's other companies' patents, then what you can do is have a freedom to operate or market search conducted. And what this is a search of the landscape in the product field that looks at kind of what else is out there, analyzes the claims for utility patents, analyzes figures for a design patent, and determines, the likelihood of you infringing a competitor's patent. And a very useful tool to kind of get started, and as Grant said with Trademark, same thing goes for Google Patents, just to kind of look for red flags, just to kind of get you started. You can go to Google Patents and there's a little advanced search link on the bottom. And if you click that, it takes you to a search page where you can type in search terms, or perhaps you want to see what patents a certain competitor has. You can type them in the assignee field. And that way just kind of get a general idea of what is out there and kind of what you may be up against. So another active company with North Coast Venture is Fabriconic that do additive manufacturing technology. And so I typed in some search terms. I also limited to the US here. That kind of got cut off in the screen grab to see kind of what some competitors are out there and things like that. And you can see some search results came up and you can click on those individually to see what claims are out there. Again, this is just a good way to get started for you to have this baseline knowledge before any final decisions are made about where to go with the product. And if you want to pursue a patent application, you'll want to consult with a patent attorney to review results. And then also similar to the trademark field. You could have an outside vendor who day in and day out, all they do is conduct these type of searches, conduct them, and then have a patent attorney review those results. So with that, are there any questions? Grant and I will kind of take any questions as far as the intellectual property field is concerned before we turn it over to Richik, and I'll attempt to turn my camera on as well, if anybody has any questions.
Stephanie, there's one question here. How likely is a business to receive a worldwide patent? I'll throw that to you. I think the answer is the probability is low, if you mean the entire world, but that's your area.
Right. So yes, I mean, it is quite possible to file in every country from which you can get patent protection. It just would be a very, very, very expensive endeavor. Generally, you want to file patent applications and try and obtain patent protection in the countries where you're selling or manufacturing your product. And so that's kind of, again, there's some strategy to go into that. You don't want to just file in a country for the sake. Also, I'm sorry, there's also, if you want to exclude some competitors, perhaps in a country as well. But if you have nothing absolutely going on in a country, then simply, again, having that patent on the wall may not be the wisest business decision.
The other question here is, if you want to hire someone to create a logo or patentable item for your company, what contracts or paperwork would be necessary to protect your idea? We could talk a lot about this, but in the interest of time, from the trademark standpoint, you'd want some type of paperwork that would say all right, title, and interest to whatever has been created as being assigned to the company. I guess on the innovation side, I know companies or folks are often reluctant to talk to companies because they don't want to reveal their ideas without having some protection. I think now we're sort of in the realm of getting a non-disclosure agreement signed to be able to have those conversations. And then I know on the patent side, there's inventor assignments of rights to companies as well, which Stephanie can talk about. But you definitely want to have some paperwork, I would say, in place that says what you're revealing to these folks is going to be kept private and proprietary and confidential. If you're revealing something that you think falls within that realm, and then also if they're creating something that is going to actually end up being yours, that the right title and interest is being transferred to you. I don't know, Stephanie, if you have more to add there.
Nope. Make sure you have an NDA, a non-disclosure agreement or a confidentiality agreement before you disclose anything.
Okay. And with that, we'll turn it over to Richik.
Sorry, we actually have, jumping in real quick. We actually have one more question. So what are the typical punitive responses if someone is determined to have violated your patent? How is penalty determined?
It depends. So again, if it's, it depends on the type of infringement. And then, if you're looking at willful, you can get a little bit more. So I don't know off the top of my head what the statutory damages are for patent infringement. But it could be, sales loss due to the patent infringement, or it could fall within the statutory, that regardless of, the sales loss, there just could be set amount. But, there's certainly been big dollar amounts with some certain infringement cases that I've seen. So I give you the attorney answer of it depends.
Thank you both so much. Before we turn it over to Richik, I did want to let everyone know we will be following up via email with the recording as well as contact information for all of the speakers. So if you have any specific questions relating to your business or questions that you didn't get to answer or ask in this session, feel free to follow up via email. With that, I think we're going to turn it over to Richik.
All right. My name is Richik Sarkar. I'm going to cover today how you can use cybersecurity to protect your information, assets, and officers. I've divided it up into these 3 different areas because I think that they are probably the most important things every company has, and you will treat, many of them have the same sort of protections involved, but you do want to treat them a little bit differently. Next slide, please. So we know a little bit about what personally identifiable information is, and here on the screen is a list of things. I think that everyone is familiar with this list. The next slide talks a little bit about, next slide, please. Protected health information. Next slide. And then this is business information, are things that I don't know if as many people think about as information that belongs to the company that needs to be protected through cybersecurity protections. Customer list, prospects list, trade secrets, just like Grant and Stephanie just discussed. You can also include trademarks and patents, business plans, strategies, and employee lists. Many people realize that, right now the focus of a lot of our data privacy laws are on public private information. But these are the things, customer lists, prospect lists, that malicious hackers are often going after as well, because they know that a company does not want those things to become public, especially their trade secrets, patents, and business plans and strategies. So, many people, when you're thinking about, what's the world of information I need to be worrying about, really should prioritize this sort of information as well, because these are the sorts of things that actually help make companies money, and these getting out into the public could damage a company's reputation as well as just their own business prospects. Next slide. So there are really 4 different types of examples of data breaches. The first is something that we'll call physical loss, a stolen or lost laptop, a stolen thumb drive, leaving a thumb drive just out in the open, database server breaches, unauthorized. That's more of an authorized person accesses your system. Stolen data by otherwise authorized users. This is when an employee, for example, let's say that there is a secretary who has access to a lot of other information than what she needs for her job. But let's say that she decides that she wants to take, or he, for that matter, wants to take the business and customer lists and sell them on an open market. That's what we call stolen data by otherwise authorized users. And then vendor and third-party breaches. That also kind of covers physical loss, data breach, server breaches, stolen data at a vendor or third-party administrator's location or server. So if you are giving your information to a third party, for example, ADP, other payroll processing companies, depending on, lawyers have a lot of people's private information and business information. They are increasingly becoming targets of data breaches with respect to trying to get access to their clients' data, and then also to blackmail law firms and accounting firms into, with the prospect of it being revealed that they were able to, people were able to steal their information. All 4 of these lists have one common ingredient. Typically, it's human error that leads to a data breach, and so oftentimes I am asked by people, what is the next big issue with respect to cybersecurity and data privacy? I tell them, flat out, I'm not smart enough to tell you what the next big issue is, but I can tell you without a doubt the problem is going to be that it's going to focus on human beings, and we've not done enough to train people to avoid those problems. Next slide. So just to kind of think about the different, in addition to problems with just the actual loss of data, a data breach really creates reputational harm for the company itself. I won't go through all these statistics, but as you can see, most people, they don't spend a lot of time parsing out whether or not a data breach was caused by a third party, whether a data breach was caused by a rogue employee. They just know that it was caused by the company and that caused them harm. Next slide. Regulatory compliance. I think almost every state, well, I know almost every state has its own data protection, data privacy law, and data breach law. One thing to think about if you do become involved in a data breach, or if your information you've discovered has been breached through something else, it's the residence of the individual that determines what law applies. So just because here in Ohio a data breach occurred, if there are individuals whose information was compromised that came from Puerto Rico, the Virgin Islands, California, Colorado, it's their data breach laws that would apply, not Ohio's data breach laws. There has been a lot of communication about a federal data breach law that has not yet happened. It creates lots of problems for companies because it requires them to follow the rules of the various states as opposed to having one cohesive rule. But every time this conversation comes up on in Washington, it usually gets thwarted by different states wanting to have their own rules for their own citizens. Next slide, please. These are a couple of the other privacy laws and standards that are out there. People forget that the FTC is a big regulator in this space, and they are the ones that actually bring a lot of actions against companies who experience data breaches. Next slide. So some of the penalties that can come into play with respect to cybersecurity, up to $750,000 in penalties for companies who fail to notify individuals of data breaches, up to $50,000 per violation of HIPAA, punitive damages, attorney's fees, and including in HIPAA, there are issues with respect to potential prison terms. Next slide. These are the areas that typically fall into problems for companies: inadequate security policies and procedures, failures to enforce policies and procedures, failure to conduct periodic assessments. I won't call this an exhaustive list, but these are the areas where you typically find that companies get into problems. Next slide. Proactive measures that companies should take are developing a written information security program, an incident response plan that talks about what needs to be done in the event of a data breach, carefully drafted confidentiality agreements, proper training, and a review of the network security that a company has. And again, I would emphasize company training. Training is really where you want to train your employees and others that have access to your system on the best ways to maintain your data integrity. Next slide. There are some cybersecurity tools that are out there. One of the things that I think is good, it's geared towards financial institutions, but is still a good tool for any sort of company, is the FIEC Cybersecurity Assessment Tool. And the link to that tool is right here on the thing. But I think that all assessments and proactive measures should really be conducted by legal counsel to ensure that you can protect as much of your cybersecurity activity under attorney-client privilege. When people rely solely on IT consultants, they really risk the privilege being waived, and it creates problems in the course of an investigation. Next slide. We'll talk a little bit about overseeing service providers, but Stephanie can actually skip forward 4 slides. But just so you know, for service providers, you really want to you want to monitor them. You want to make sure that you understand what's going on with their companies, and you want to understand what sorts of risks they are putting you at. And actually, we can go to the next slide here. One of the things that the FTC is focused on, and this began when they were considering the Internet of Things and how many different ways people are putting their personal information online through the internet, is the concept of data minimization. And really what that focuses on is only keeping as much data or creating as much data as you need to satisfy the needs of your business with respect to consumer data. This is a very important thing. This is actually the core concept behind a lot of the state laws, including the laws in California and Virginia. And it's something that most companies need to understand, is that if you are keeping data longer than you need it, all you are doing is maintaining a really, I use the analogy of, you get as much pulp out of an orange as you, a juice out of an orange as you can. And what you're left with once you get all that juice is just pulp. The longer you keep that pulp on your system, it becomes, it just starts to rot, is creating a data liability for you. Next slide. So an information security program is the cornerstone of any sort of data privacy program, and it's a really it's what you need to do to kind of protect yourself against the threats internally and externally. It's really there to kind of ensure the confidentiality of customer information. Stephanie, why don't you go all the way to the second to last slide before our faces? There you go. When we're talking about critical cybersecurity questions, and I see that we're running up on time, and I want to get everyone out of here by 1. One of the things that you should really ask is, what are the company cybersecurity incident response plans? Are you properly maintaining and managing your third-party vendors? Do you have the proper insurance to cover a cyber event? There is a slide that we have that we went over that discusses what elements you really want in your cyber insurance policy. But what they really focus on are, you want coverage that addresses the damages that have been incurred by you, and you want stuff that will address damages that may have occurred to third parties. And you really want to find a cybersecurity vendor, an insurance vendor that understands those different things. I know that we're up on time, and I don't want to keep anyone here longer than we have. Alexis, are there any questions in the Q&A that need to be addressed?
Yes, we do have 2 questions. What are some special
Okay.
considerations for health tech startups in terms of storing health-related data?
One is, I would segregate the health-related data and data that you get from your third parties onto a different server and in a different place than I would with the rest of your data, just to kind of create a particular security control. The other thing with regards to health related information, I'm a big believer in dual controls for critical cybersecurity information, protected information. So in this instance, it would be health related information, individual information. But what dual controls really mean is that 2 people are necessary in order to access a database. You don't want one person to be the only person that can access critical information systems. But there are other things in place. But one of the most common things that I would do is put it onto a separate server, put it in a separate area, so that there's at least 1 or 2 more lines of defense between a hacker and that system, and also make sure that no one in your company that shouldn't have access to that system gets access to that system.
Great. And then, is end-to-end encryption a good protection mechanism for sensitive data storage?
Yes. What that basically means is that from every moment that the information is on your system and goes through it, it's maintained in an encrypted state. There are different mechanisms to do that. There are different programs and security companies that can help you with that. But yes, in for what I consider to be critically sensitive information, I believe end-to-end encryption is a very useful tool to maintain integrity. But again, people need to be trained on what that encryption is and what needs to be done in order to maintain that encryption.
Great. Thank you all so much. Those are all the questions we have in the chat right now. To the Dinsmore team, thank you guys so much for taking the time out of your afternoon to walk us through IP and cybersecurity mechanisms. We really appreciate it. For all those that attended, we do have 2 events coming up for North Coast if you're interested. We have an event on April 13th called One Crucial Thing. We'll have 20 to 25 speakers present 2-minute pitches about one crucial thing to drive success for a business. And then we have the next installment of our Lunch and Learn series will be April 29th with BD Law, and their topic will be navigating a down round. So feel free to attend either of those if you're able. As mentioned, a recording as well as contact information for the Dinsmore team will be shared via email this afternoon. Feel free to reach out to anyone on the Dinsmore team with any questions specific to your business. Otherwise, thank you all so much for attending. Have a great rest of your Monday afternoon, and hope to see you at an upcoming North Coast or Dinsmore event soon.
Thank you, Alexis.
Thank you.
Thank you.
Just one quick thing. I know that the slides can be available through any one of us.
Great. Thanks so much.